Hi everyone, and welcome to our webinar on Deal Structures 101. That's all about understanding equity, loans, safes or ASAs, and convertible notes. My name is Sarah Aldersley, and I'm a practice leader in the corporate team at LegalVision. Before we begin, just a couple of quick housekeeping items. So you will receive the recordings and the slide in your email afterwards, so don't worry too much about making lots of notes. If you have any questions, please submit them in the Q&A box and then I'll answer them at the end. And you'll also be sent a short survey after the webinar just to give some feedback, so it'd be great if you could complete that. Also, for the next 48 hours, you're eligible for a free consultation with LegalVision to discuss how we can help your business. So if you want to take advantage of that, please do provide your contact details in the survey at the end. Great. So today we will be discussing the best vehicle to raise funds, dual company structures, loans, equity, convertible notes, ASAs, which you might also have seen referred to as safes, the actual cap raising process, and then as I said before, we'll do some Q&As at the end. So to start with, the best vehicle to raise funds. So the best and most industry standard vehicle to raise funds is within a company. So you can only issue shares or other securities which are convertible into shares, for example, convertible notes and ASAs, like we'll be discussing later, if you actually have a company to issue that securities in. You can have a single company or a group structure, which I'll be moving on to in a little bit. And even if you're raising money through debt, for example, you're taking on a loan, a company structure is still really beneficial because your personal assets are then generally protected, because there's a unique feature of a company, which is that it has a separate legal identity, so it has limited liability. Of course, you might be asked for a personal guarantee, but if you're not, the loan's just with a company, then that protects you. And this also just applies generally to your operations, really, because any contracts that you enter into as the company are then the company's assets or liabilities, not your own personal liabilities. So I mentioned earlier the group structure. So you can have what's called a dual company structure or a group structure. So this is where you'd have a holding company and then one or more operating companies sitting underneath it. So it's the operating companies that will enter into contracts, for example, with suppliers or clients or employees. There's a lease and it will be the operating company that's the tenant under the lease. And then the holding company owns the opcos normally 100%. And then that holds the group's assets such as IP and cash. So again, it's sort of a liability limitation mechanism. So if there was ever a claim against one of the opcos, then the kind of valuable assets sitting in the holdco are separate from that company and so are more protected. And typically, if you do have this group structure, then all shareholders will hold shares in a holdco. So there can be certain scenarios where commercially it makes sense for shareholders to hold shares in just one of the operating subsidiaries, but typically, and especially investors, they'll want to sort of be coming in at the top level. So moving on to the first discussion point of today is a loan. So as I'm sure you're all aware, simple definition of a loan or a debt is when someone lends you money and then you promise to repay that money at some point in the future. So interest may or may not be payable on the loan. Typically, in a commercial arrangement, it is payable. It can be a flat rate, can be tied to the base rate of a particular bank or the Bank of England, or we sometimes see it so actually it's pegged to profits of the company, for example. You might agree to repay a loan in installments, so monthly or quarterly, for example, or just do a balloon payment at the end when you reach the maturity date of the loan. So normally, if certain events occur, which are normally called events of default, that makes the loan immediately repayable. So, a typical event of default is you don't pay any money that's owed when it's due. So if that happened, there might be a grace period that you have to go past, but if you still haven't paid by the end of that grace period, then the lender could then accelerate all outstanding payments under the loan. The lender might also want to take security over some of your assets. And what this means is if the loan is secured and you default, as we just discussed, then the lender also has the right to take the assets that it has security over, sell them, and then use the proceeds of the sale to repay their debt first. Then the rest goes to the company. So obviously that gives a much greater protection to a lender, but isn't as ideal for the company itself because you actually have sort of granted another interest over your assets, and there could be a chance that kind of they go out of your hands at some point if you do default. So an advantage of a loan sort of against equity is that you don't give up any ownership of your company. So if you're quite confident that you will be able to repay the loan amount, then you might decide that this is a good option for you, because then at the end of the day, once you've repaid the loan, you would still own 100% of your company. Also, the flip side of that is that you do actually have to repay the amount that you've borrowed. So, that could be a risk to the business. And depending on what interest rate you can get, it could end up being a potentially expensive way of getting in financing. So that's the loans. Next is equity. So this really is shares. So shares represent fractional ownership of a company. So an investor will agree to give you a certain amount of money in return for a set number of shares, or perhaps a set number of percentage holding of your company. Usually investors will agree to give you money based on what's called a post-money valuation of the company. So all this means is if the investor, for example, said, I want 10% on a post-money basis, this means that they want to own 10% of your company after their investment. So for example, if you had 1,000 shares in issue, you're the founder, you promised the investor 10% equity on a post-money basis, and they're going to give you 50k. So that what that means is for their 50k, they'll get 10% of the shares after they've invested. So how do you calculate the number of shares to give them? Well, you've currently got 1,000. You know that after the investment, the investor will hold 10%. So your 1,000 shares is going to represent 90%. So you can do 1,000 divided by 90. That gives you the amount of shares that would equal 1%. So here it would be 11.11111. You times that by 10 to get the 10%. So as you can see, that gives you 111 and 11 pence, rounded down. You can then also calculate the share price, because you know the investor's giving you £50,000 and they're going to get 111 shares. So 50,000 divided by 111 is that 450.45. So that's the price that they're paying per share. So as you can see, rounding actually can make quite a difference. Here you've got the 111.11. That could obviously be a larger number of decimal points depending on how many shares you have. So the more shares you have on issue to start with, the more accurate you can be to give someone a set number of shares, and you don't have to worry about rounding up or down. So if you only have, say, 1 share or 10 shares or 100 shares, even 1,000 shares on issue to start with, we often recommend that you do a share split before doing a capital raise, just so that the existing shareholders have more shares before the investor comes on board. And then, as I said, you can sort of be more accurate when you're doing those calculations. Also worth noting, you see this quite a bit. So, founders often promise investors a set percentage of the share capital, which is fine. Obviously, it's a good way to think about it. I think a lot of people conceptualize investments by this person's going to end up with 2%, for example. I'm going to get diluted down to X%. But when you're talking purely in percentages, it's just really important to understand at what point is that percentage calculated. So if you have multiple investors investing in tranches, for example, at what point should the investor that you promised, say, the 2% to, at what point should they hold that 2%? So should it be, if you had 5 different investors investing, are they expecting to hold 2% after everyone has invested? Or is it that they're getting shares now for 2%, and then if a new investor comes in, then they get diluted? So obviously you can see here it could make quite a big difference. If you're kind of doing a capital raise and completing your round at the same time, it shouldn't be too much of an issue. But you often see it where money's being drip fed and the founders are just promising different percentages here and there. But not necessarily thinking, okay, but what percentage, what number of shares does that percentage mean post everyone getting their shares? Actually, you've given away quite a lot of your share capital by then. So that's just something that's quite important to think about. And just to quickly mention, if you're issuing shares and you qualify for SEIS or EIS, then investors can get that tax relief. It's really just an incentive to incentivize investors to invest in early stage, sort of riskier companies. So obviously with a loan, you can't get that because their money isn't at risk. So it's also important, kind of much like I mentioned with the percentages with the investors in tranches, it's also important to think about if you have or are going to have an ESOP. So an ESOP is just an employee share option plan. It's a mechanism that's used quite frequently by early stage companies. So you issue employees with options, which can then be converted into shares. You can also issue shares to contractors, but they can't benefit from the sort of tax efficient schemes that you'd normally set up for your employees. So the reason why these are good is if you are early stage, you're not making as much revenue or profit, you can't offer wages at the market rate. You can incentivize a really good employee to join you if you also offer them some equity. Obviously, the more they perform, the increase in value in the company, therefore the increase in value in their equity. So it's sort of win-win for everyone. If the certain criteria are met by both the company and the employee, then they might be able to enjoy beneficial tax treatment, like I briefly mentioned earlier. So the most typical one is called an EMI scheme. So it basically prevents the employee from having to pay income tax if they pay a certain strike price when they exercise their options. So for the purposes of this talk, the most important takeaway is what is the option pool and how does that affect investors? So a lot of people think an option pool is actually sort of an issued number of options that are just sort of held there until you're ready to actually give them to a certain employee. So that's not quite right. It's actually kind of a theoretical pool that has been created, which effectively just is the authority of the directors to issue options up to an agreed percentage to employees without having to go and get shareholder approval. So that authority is normally included in your articles or your shareholders agreement. It tends to be anywhere from sort of 5% to 20% at the higher end of things. So the investors, the directors can really just say, okay, well, I know I can issue options to this person without going to shareholders because I've got that approval baked into my articles of association. As you can see, in the same way that I was talking about percentages earlier, an investor might be thinking, okay, well, you've got an ESOP or you don't have an ESOP, but you're probably going to want one. And they can be, investors often like it when companies have these because they are a really good tool to be able to incentivize staff. So they might say sort of as a condition of my investment, I want you to create your pool and I agree to it being 10%, for example. It's because they want to understand what their fully diluted shareholding could be. So that's how much of the shares that they could hold if the whole ESOP pool ended up being issued and converted into shares. So sort of on this graph on the slide, if you gave your investors 10%, which is that orange chunk, and then you gave employees different ESOP options that they exercised, then that would dilute down the investors as well as the founders. Whereas if you agree to effectively bump up the number of shares that the investor's getting, so that once you've issued your ESOP in full, so here it's a 10% ESOP, once you've issued that 10%, the investor still has 10%. So you're sort of factoring in the maximum amount of ESOP you could issue when you're working out the share price that you're giving investors. So they basically get bumped up. So if you didn't actually issue anything under the ESOP, they would have more than 10%. But if you did issue the whole ESOP, they'd go back down to 10%. So effectively, it means the founders take all the hit of the dilution if you're issuing options under the ESOP. Great. So the next one is convertible notes. So these kind of sit between a loan and equity. They're kind of a hybrid debt and equity instrument. They will convert into shares or be repayable on particular trigger events. So These tend to be a priced round, so you're doing a capital raise, some sort of liquidity event, such as a share sale or asset sale, or if you hit the maturity date, and none of those things have happened yet. And to incentivize investors to come in at your convertible note stage and kind of invest earlier than other investors, then generally what you do is agree to give them a discount if the convertible note converts because you're doing a priced round, a capital raise, then they would get a discount to the share price paid by everyone else in that round. For example, it tends to be around 20%. It can be anywhere from sort of 10 to 30, we see. And also you can set a valuation cap. So this is a predetermined sort of theoretical valuation of your company, which can be used to calculate the share price on conversion. So really you want to set this as close as possible to what you anticipate your valuation will be when you do your cap raise, which will then trigger conversion. Because what happens is the investor will get a number of shares, which gives them the most shares that they can get if they converted at either the valuation cap or the discount rate. This is assuming that you're doing a capital raise and that's what's triggering the conversion. So for example, if your valuation cap was the company was worth 2.5 million, but you were raising at 3 million valuation, actually it could be the case, and here it probably would be, if you were giving a 20% discount, then actually it'd be effectively like your valuation is 60,000 lower because of your 600,000 lower because of your £3 million valuation, which is going to be lower than your valuation cap. So you sort of compare the two, say where would the investors get more money, more shares for their money, and then you choose that one. So just to be clear, the discount doesn't get applied to the valuation cap price. That sometimes people get confused on that. You have your valuation cap price, and then separately you have your discount to the amount that the other investors are paying. So for example, if you're raising at £10 per share, you'd given an investor a 20% discount under their convertible note, they'd effectively be paying £8 per share. So interest can also be payable on a convertible note because there is a debt element to it, and you can roll it up and convert that into shares at the end as well. But obviously it is, as I said, a debt instrument. So what that means is if you haven't done a capital raise or you haven't sold your business by the time you reach a maturity date, then typically the lender gets to choose, do I convert the outstanding amount into shares or do I get repaid? So again, it can be good for the company to do a con note, because then, especially if you can negotiate it, so the company gets to decide what happens on the maturity date. Because if you do have the cash, you can just pay them back with their interest and then that's it. You don't lose any of your shareholding percentage. Otherwise, if you're sort of struggling for cash and it makes more sense to convert, then you can obviously give them shares. So there are different advantages and disadvantages of this. So it's generally cheaper and faster to document than doing an equity round. You're not giving investors shares yet, so you don't need to be negotiating your articles of your shareholders agreement. You can also defer valuing the business. So if you're not quite sure what the business should be worth, or you're between sort of two equity rounds, then this can be a good instrument to use. Obviously, you do need to agree on the valuation cap for the conversion mechanics, but it's not kind of as set in stone as what the valuation is on a price round. You could use a discount instead. And also it's really good price protection for an investor. So it's even better than, you can sometimes issue shares and have what's called a ratchet anti-dilution clause. So if you ended up issuing shares later on what's called a down round, then you'd bump them up. It's actually better for them to sort of invest early, not get the shares yet, wait and see what the price is and get their discount. So sort of the company takes on all the risks. There's no minimum price and the investors have to pay, but there is a maximum price. So obviously you can see it's very investor friendly. There are also disadvantages though. So if you set your discount or your valuation cap at a much lower level that isn't suitable, you could end up significantly diluting the existing shareholders. So that's obviously not great. The conversion mechanics can be difficult to understand. You're looking at valuation cap versus a discount. You might also have an ESOP that's getting factored in. So to actually calculate the share price can be a bit confusing, especially if you've got multiple instruments converting. There is a maturity date. as I said before. So it is a debt instrument, so you might actually have to pay back the loan plus interest if the lender elects that to be the case on the maturity date. And also worth flagging, you can't get SEIS or EIS relief for your investors if you're using a convertible note. So the next one is an advanced subscription agreement, which you may have heard being referred to as a safe note before. In the US and Australia, they tend to call them safes. But yeah, we tend to call them advanced subscription agreements. So they're very similar to convertible notes. The difference is that generally there's no maturity date, which means it's not actually a debt instrument. It is pure equity. If you never actually end up triggering the conversion by doing a capital raise or selling the business, then this advanced subscription agreement just won't convert. It will just sit there until either of those things happen. And there's also generally no interest payable. So they're the big differences. However, we are increasingly seeing people put maturity dates into safes or ASAs. That tends to be because depending on the economic climate at the moment, obviously, there's maybe reduced frequency of raises. So investors are less certain that if they give money under an ASA, that actually they will get shares at some point. So they want to make sure that actually, if you reach a certain date and you haven't done your capital raise, they will actually get their shares. So we are increasingly seeing maturity dates included in ASAs. Also, on a con note, I said often the lender has a choice if they hit maturity to get repaid or for the note to convert. With an ASA, typically it will be that it will convert. It won't be the case that you ever have to pay the money back. But as I said, normally there is no trigger that has to happen by a certain date in order for it to convert. It just sort of stays outstanding until it happens. But nowadays we are seeing that people are including a maturity date. And another reason why that's the case is because investors can actually get SEIS or EIS relief when they convert the ASA into shares, as long as HMRC views that ASA as a pure equity instrument, which is why you often need a maturity date. It tends to be within 6 months for them to say, yes, okay, it's equity, it's not debt. And then you can actually get that relief as well. So that's another good benefit of an ASA. Great. So lastly, just wanted to touch on the process. So in terms of timing, it really varies. Like sometimes we have clients come to us and they're ready to go with an investor or multiple investors, sort of heads of terms have been agreed and it's really just documenting the raise. So, you could do that in a number of weeks. Conversely, you can see it going on for anywhere up to 6 months if it's kind of complicated deal terms, there are multiple investors, certain things that have to happen before the raise completes. So it really does vary depending on kind of the complexity of the terms and also whether the investor wants to do DD, because that can extend the timetable. So the first step is to get the term sheet agreed. So I really would recommend, if you're given a term sheet by an investor, give it to your lawyers to review before you sign it, because often, there are things in there that maybe companies don't understand or are a bit sneaky from the investor perhaps. And it's very hard to then renegotiate that point if you've already signed the term sheet. So definitely get that reviewed. I mentioned DD earlier, so an investor might want to do some due diligence. This can happen before the term sheet stage, but typically happens afterwards. So that could be like sort of legal DD and financial DD. Depending on the extent they're doing, that obviously will affect the timeline. Then once they're reasonably progressed in their DD, we'd start drafting the document. So depending on the investor, if they're very sophisticated, they make a lot of investments, they tend to be responsible for doing the first drafts. Otherwise, the company's lawyers would do the first drafts. And what you would have, if you're just doing kind of a pure equity round, you would have a subscription agreement, which sets out what the investor's paying, the number of shares they're getting, warranties given by the company and sometimes the founders as well. And then you'd have your articles and shareholders' deeds. So they're the two documents that sort of set out the governance terms of your company. So things like who has the right to appoint a director, certain business decisions, how they get made, if the investor has any particular information rights, things like that. So they would all go in those documents. Then there'll also need to be some ancillary documents like board resolutions, shareholder resolutions to waive preemption rights so that you can issue the shares to the investors. So you prepare the documents, get them agreed, and then you're ready to go ahead and complete. So you'd need to make sure your board and shareholder resolutions are signed, so you do have the right authority to actually issue the shares, obviously take the cash in from the investor, and then you would update your members register and company's house to show that those shares have been issued, and then give the investor a share certificate. Obviously, that's if you're doing an equity raise. If you were just doing a con note or an ASA, there are resolutions that you'd need to sign to get authority to enter into those documents, but you wouldn't need to update company's house, for example, because you haven't actually issued any shares yet. Great, so that concludes the main part of our webinar. Just before I move on to the Q&A, there is a link here, QR code on the slide, for you to download our UK Startup Manual. So it's just a really useful resource for early stage companies in the UK. We've also got another webinar coming up next week on Tuesday. It's 11 o'clock. It's called Common Legal Pitfalls for excuse me, SaaS and online businesses. So if you're interested in that, then you can register at our events page on our website. And you may or may not know that LegalVision has a membership. So just while you're submitting your questions, I'll just take a minute to tell you a bit about the membership. So by becoming a LegalVision member, your business will get unlimited access to our full team of specialist lawyers for all of your business as usual legal needs. So it's effectively like having an in-house counsel, but for a fraction of the cost. We can assist you with things like unlimited document drafting and reviews of all your business contracts, unlimited legal advice consultations where you can jump on a call with a lawyer to discuss a particular issue that's cropped up, and also things like unlimited domestic trademark registrations. So as a member, you don't need to worry about the cost of lawyers ever again. It's sort of a fixed fee pricing model. Also, if you're in-house counsel, we also do offer a dedicated service to manage your sort of higher volume business as usual legal tasks. So if you're interested in that and you want to learn more, you can request a free consultation when the survey appears at the end of the webinar. So we've got about 15 minutes left. I'll move on to the Q&A. So there were some questions submitted beforehand, and there's any on the chat yet, but if you do have a question while I'm talking, please do add it. So one person asked, avenues to raise capital, how do we decide how much equity to give? So this is a question we get asked quite a lot. Really, there's sort of no hard and fast rule. So you can base it on what the valuation of your company is, and obviously the amount the investor is then prepared to invest. If you're doing that, I would suggest, you want at least 6 to 12 months of runway. You don't sort of want to be taking on some cash and then in 3 months running out and then needing to start the whole process again. So think about, based on your business plan and your forecast, how much money you're actually going to need to realistically, move ahead with the next stage in your business. And then based on the valuation, obviously, again, there's sort of no hard and fast way of doing this. If you're really struggling, you could speak to a valuer about how can I value my business for the purpose of this investment, for example. It can be hard. So otherwise, a lot of people sort of do it backwards. So they'd think about, okay, I don't know how much my company's worth, but this is the number of shares I have. I'm going to be doing this raise, probably going to need to do another 1 or 2 at this time. I'm going to have an ESOP. If I gave away X% each time, what would I end up with? Am I comfortable with that? So sort of work backwards in terms of how much equity you're willing to give away. Based on what the investor's prepared to pay for that, that will then imply what your company valuation is. So yeah, there's not really kind of a legal answer to that. It's obviously a commercial decision for the founders. But yeah, definitely worth thinking about the long term and not, well, if you can avoid it, trying to give away as little as possible now so you don't kind of down the line end up diluting yourself too much. Obviously, there are sort of magic thresholds in company law. So you've got 75% is your limit for a special resolution to pass, and then more than 50% for an ordinary resolution. So quite often founders want to always have above that 50% mark, just because it gives them some special rights under company law. So that's kind of a good marker to think about. You still then have control of the company if you're above that threshold. Great. Someone else has asked things I should be asking a potential partner before investing in the business. So I'm assuming here it's from the point of view of the investor, rather than the company. Or it could be, a new co-founder coming in or something like that. Um, so before, committing funds in return for shares, what I would suggest is that you undertake at least some light touch legal due diligence. So things like looking at company's house filings just to get a feel for what the company's done, how long it's been around for, how many shares are on issue, who are the shareholders. Also tying this in with the company registers, so making sure that what's on company's house does actually match the registers and there's sort of nothing funny going on there. So it's quite old fashioned, but it's actually the registers that are the definitive document in terms of who is the shareholder, not company's house. I think a lot of people just look at company's house and think, okay, that's definitely the position. It might not be up to date, for example. So yeah, look at the registers as well. And then depending what the company does and sort of what its key assets are, if there are ways that you can verify that, yes, actually they do own those assets. So a good example is, branding. If the brand's really strong and they've got a trademark, you can do an IPO search to confirm they do actually own that trademark. If there's other IP that they've developed, but maybe it's been developed not in-house, so they've kind of got an overseas, often you see that happening in overseas developer to design their app, for example. You can ask for a copy of that contract to make sure they do actually own the IP in what they've had developed. Also, things like if they have material customers, you might want to look at the contracts with, say, the top 5 customers they have, just so that you understand, how locked in are they? Is it going to be quite difficult for a customer to get out of that? Have they exposed themselves to a lot of risk in that contract? Are there indemnities, things like that? So yeah, that's typically what I would suggest in terms of light touch legal DD. Obviously, there's going to be commercial and financial DD to do as well, that I'd recommend you get an accountant involved to help you with if you're unsure. So, things like looking at their latest accounts or historical accounts, their forecast, their business plan, understanding who's actually working in the business. Are the founders actually properly invested? What you can have is in your articles of association, you can have sort of effectively reverse vesting. So the founders have all of their shares, but if they left the business within a certain amount of time, or perhaps they left in like bad leaver circumstances, a number of their shares wouldn't actually be vested yet, and they'd have to sort of transfer them for no value. So it really does lock the founders in to working for the business for an amount of time to make sure they have actually had all their shares fully vested. So that can be something that's really key, because obviously most of the time you're investing in a company, it's the people you're investing in. You don't want to give all this cash and then the next month the founder decides, actually, I don't want to do this anymore, and walks away and the business folds. So you kind of do want to lock the founders in as well. So that's kind of the things that I would be looking at. There was another question then about loans. So one, it said intercompany loans between partner and subsidiary and their impact on credit rating. So I guess this is slightly outside the remit of this presentation. But I mean, intercompany loans are common. There are sort of fewer tax consequences if the loan needs to be waived if it is an intercompany loan. In terms of sort of credit rating impact, I haven't sort of heard of that, so it's be a good idea to speak to a bank to understand what they're looking at if they're making a credit decision. But otherwise, what I would just say is, obviously, it is still a loan, so it would show on your balance sheet, and investors would normally obviously look at the group as a whole. So if actually it looks like, oh great, this company has loads of money in the bank, but really it's owed as a loan, sort of tracing that back, who's it come from? So yeah, they will sort of need to be aware of any loans that are outstanding, because that obviously then affects the valuation of the company. Just one last question by the looks of it. So someone's just written, compare SaaS with license fees and the pros and cons. So this webinar was just about sort of investment structures. So what I'd recommend is, as it happens, the webinar next Tuesday is actually about common legal pitfalls for SaaS and online businesses. So definitely recommend that you join that one, and they'll be going into details about SaaS models. So that sounds like it would be a good one to have that question answered. Brilliant. So I'm a bit ahead of time, but that's all the questions. So hopefully, you found today useful. If you do have any questions that you haven't thought of yet, or you do want us to answer separately, then feel free to pop them in the survey at the end. And also, if you want to book in that consultation for the membership, then that's how you can do it then. So while this was a free webinar, we do really value your feedback. So please, if you have time, complete the 30-second survey at the end. So thank you very much, everyone. Thanks for joining us.